Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 p.m. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere, to let the conference see the light of day again and at the same time to show compassion and empathy in our community. Let's watch the show together. It was this experience that became the spark for us wanting to help more people. We approached charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. The first speaker tonight is Christian Swift, who is the Operations Director at +3 Consultants, followed by Peter Hiebler, who is a Director at Turner Commercial Advisory Services, and then Serene Hiew, who is a Partner at Harrell & Lamb Partnership. Without further ado, let the show begin.
Hello and welcome to this talk given by +3 Consultants to the Construction and Claims and ADR Conference 2021. My name is Christian Swift and I am the Operations Director here at +3. And today's talk will be on a strategic approach to successfully managing projects. So today we thought we'd take the talk as a walk down the river on the proverb, one who walks by the river may end up with wet feet. And along the walk today, we'll be looking at global disruption, COVID-19, some tips around contract administration and keeping your feet dry, some practical advice and external support. Disasters and disruption have happened throughout history, and COVID-19 is no different. However, due to globalization, we are now all more affected and impacted, particularly in the construction industry, as we source labor, plant and materials from overseas, and delays and disruptions which are caused due to these pandemics. So as we walk down the river, what potential wet feet have been experienced in the last 30 years, the events of which were considered at the time to be catastrophic with far-reaching consequences. And yet we came out of the other side stronger with lessons learned and a new approach. So let's look back at 1990 when Iraq invaded Kuwait, leading to the first Gulf War, and the effects surrounded by this global disruption event. In 2001, we had 9/11. And in 2003, we had the second Gulf War. In 2008, we had the global financial crash. And in 2010, we had the eruption of the volcano in Iceland, which caused global disruption to travel. And we also had in 2010, the Arab Spring, which was a political uprising in the Middle East. 2011, we had the earthquake and tsunami at the Fukushima nuclear power plant in Japan, the effects again of which are being felt today. 2012, we had MERS, the Middle East Respiratory Syndrome, affecting not only the Middle East, but globally. In 2014, oil price crashed from $120 a barrel to around $20 a barrel, affecting projects globally, particularly within the oil and gas sector. And in 2016, we had Donald Trump elected as the President of the United States of America, potentially another global disruption. 2017, we had the blockade of Qatar. Used to work in Qatar, experienced this at the time, with the land, air and sea embargo causing delay and disruption to the projects due to delivery of plant, labour and materials from the surrounding GCC countries. And in 2018, we had the Ebola outbreak in Africa. And of course, in 2020, we had the COVID-19. The effects are being felt today with a global stock market crash, job losses, and last year, for the first time in history, oil prices fell to a negative value. So COVID-19, well, many say it must be force majeure, but beware. Despite advice to the contrary, be cautious of the force majeure route. We are seeing that governments and employers are avoiding force majeure. In some instances, we see that in some of the claims that we are dealing with. The basis of force majeure is generally to relieve the parties of their obligations or to release them entirely. But it's not a vehicle for financial compensation, and if accepted, it will only award time and will not compensate losses other than time. So what's your intent and what do you want to achieve? So if not force majeure, then what? Well, plus these advice is do not focus purely on COVID-19, but broaden the thought process. What is the impact? What is the effects of COVID-19 on the project? Has it resulted in additional or varied works? Has it caused critical delays to the completion of the works? Has it increased the time-related site costs, resulting in prolongation? Has it increased executing the direct works? Has it resulted in disruption? So review each situation differently from a different perspective and ask yourself the question, how has COVID-19 impacted my contract? So if we look at these points in a little more detail, so has the COVID-19 pandemic resulted in extra works? We had to construct the works in different sequence, using different methodology, and potentially you've incurred additional or varied works, leading to a claim for variation. Has the completion of the works been delayed, potentially giving rise to an entitlement to an extension of time claim? Has that delay resulted in increased time-related costs? Have you increased the cost of executing the direct works? Has HSE restrictions resulted in direct works being less efficient, thus giving rise to an entitlement for a disruption claim? As with any claim, we've got to look back and link it to the contract. What does the contract say? So public authorities implement restrictions on the amount of labour We've seen that now with the enhanced SOPs. Likely result of that is critical delay, resulting prolongation costs. If to follow in this instance will be an extension of time claim with a prolongation cost claim. As the public authority implemented restrictions on labour gang size, likely result in efficient working, direct costs increase. Further to follow, disruption claim. Have you been instructed to provide additional site welfare facilities? Has it resulted in additional works? Likely result additional works, further to follow a variation to the contract. If you had to prioritise your work areas, likely result additional works, inefficient working due to changes in sequence, further to follow a variation to the contract, potential disruption. Has the free issue equipment been delayed? Has the employer committed to providing equipment? Likely result, a critical delay and prolongation cost claim. Further to follow, extension of time, prolongation, disruption. Has the contractor's equipment been delayed? Likely result, contractor's critical delay. Further to follow, check the contract. Are there alternative suppliers within the contract? Has the contractor demonstrated mitigation? So how do we keep our feet dry along this river walk? Well, we've all experienced these issues, and COVID-19 is no exception. And we're all concerned with COVID-19's impact on completing the project, our contractual commitments, and maintaining a healthy profit margin. Look at the cause and effects. Don't get too bogged down with the effects only. Link it to cause. You have a variation, give notice of the variations, make submissions. Include the status of the variations. Are they under review? Are they pending approval? Have they been instructed or not yet agreed? Include them within your monthly applications. Maintain good cost control. What was envisaged at tender? What is happening now? And why is there a difference? And monthly reports, probably the most important contemporary document. It provides a snapshot, the status of the project at monthly intervals. Maintain it, but do not be tempted to over-report the performance. Likewise with programs, keep the programs updated on a monthly basis. Again, do not be tempted to over-report. Whilst it may keep your head office happy, the progress is good, it may work against you in grounding the claim for delay or disruption as you're relying on documents which are inaccurate. Notices, very, very important. Delaying for the right time could have an impact on the validity of your claim. Be mindful not to be time barred. Whilst you may consider a notice will affect your relationship with the other party, be sure to follow the contract. If the contract says you must provide, then please provide and adhere to the timescales. And why are we doing this? Well, it's providing clarity and transparency to the employer, keeping them aware of what's happening. Do they need to go back to seek additional budget or change the scope to reduce the cost? If the engineer, the SO, the architect rejects the notice of claims, why? Potentially you're time barred. So again, follow the contract. Maybe the claim is not presented in a clear and coherent manner. Can the employer, the engineer understand the claim? Perhaps they're not as close to the issues as you are. Be clear when you're presenting the claim that it's understood. Perhaps it's not fully supported with documentation. Every statement made must be fully supported. If you're relying on an instruction, piece of correspondence, make reference to that and include the document within the appendices. And get support. If you need help, let us help. So final thoughts then on COVID. It's not just COVID-19, okay, it's had an unprecedented impact. And at +3, we can help you. Come and talk to us. Get in touch. Details are on the last slide. We can help you manage and secure your time and cost entitlement. We're here to support you. We're here to help you. So some tips around presenting your claims. Disruption. Don't present a global claim as it fails. There's various methods of assessing disruption under the SCL protocol. And we have a unique method, Construction Dynamic Systems. We can help you provide an alternative approach to producing a fully substantiated disruption claim using system dynamics modeling. So please get in touch. Media, again, be clear with your claim. We have an in-house forensic graphics team. We can help convert your written claim into a short movie to secure an amicable settlement. So some final thoughts from me after my years in the industry. I'm not an expert in building a bridge, so I would not consider building a bridge without engaging some engineers specializing in the bridge design. So please let us help you with your claims. So I hope you enjoyed the presentation. Thank you very much.
Good afternoon, everybody. This afternoon, I'm going to be speaking a little bit about the latest developments in assessing concurrent delay, a subject which is very prevalent and common in today's construction industry. Let me just share my slides with you. Okay. Okay, so there still isn't any standard approach in assessing extensions of time or delay damages where there is concurrent delays. There's been substantial decisions over the last couple of decades at least by the courts, but whilst those do appear in the first instance to bring new guidance on concurrent delay, these decisions are often actually only applicable to the specific circumstances and the facts around each individual case. So they may not actually be applicable to a specific scenario that you may be looking at in terms of concurrent delay. So care just needs to be taken as far as that's concerned. So the assessment of concurrent delay still remains subjective and quite often still gives rise to differences of opinion and actually disputes all in itself. There still actually isn't a definition, a standard definition of concurrent delay. There are some quite common or popular ones, which I'll go through. But as you'll see, there is no standardization of even the definition. So one of the more popular ones that's been used in several court cases, legal cases, is one by John Marin, QC, where he defines concurrent delay as the period of project overrun which is caused by two or more effective causes of delay, which are of approximate equal causative potency. Another definition, which is quite popular and well known, also is the one by the Society of Construction Law, the Delay and Disruption Protocol. And that one states it as being the occurrence of two or more delay events at the same time, one an employer's risk event and another a contractor's risk event, and the effects are felt at the same time. So this definition requires the delay events to happen and finish at the same time, which, as we'll see a little bit later, is not very common at all. Now, if we look at the United States, they've got a slightly less rigid approach, I would say, in terms of how concurrency is defined. The AACE definition is concurrent delay occurs when there are two or more independent causes of delay during the same time period. So if we have a look at what the definition of true concurrency is where you've got a project's critical path that's impacted by two delay events, one an employer delay event and another a contractor delay event, which start and finish at exactly the same time, have got an equal causative potency, and they both, in their own right, delay the project by the same amount of time. Now, this, I think, as anybody, as most people in the construction industry who assess these type of scenarios and concurrency will find that this actually hardly ever happens. In my experience, I've not yet come across a true concurrent delay scenario, and therefore, arguably, this definition is too narrow, and it's somewhat limited in its practical application. What tends to happen much more often is this other example here, which is another example that's given by the Society of Construction Law, whereby a project is impacted by two delay events again, one a contractor's delay event and one an employer's delay event. But the contractor's delay event starts earlier and finishes later than the employer's delay event. And there is merely a period of overlap or concurrent delay, in this example for 2 weeks, around about the middle of a contractor's delay, or perhaps a parallel delay, as it's sometimes known. So there's actually two different views on how this concurrency should be approached. View number one is that both events are effective causes of delay for that period of overlap, for that 2-week period of overlap, and that the contractor is entitled to extension of time for that period. This view has been supported in earlier English appeal court cases. For example, the Henry Boot versus Malaysia Hotel case back in 1990. And this approach is quite often known as a Malaysian approach. There is another view to this scenario, and that one is the one promoted by the Society of Construction Law, actually, which says that the employer's delay does not actually result in the works being delayed, as the works were already in delay by the contractor. So if you look at this scenario from a purely critical path analysis method, it's evident that the contractor's risk of it actually is the only effective cause of delay. And because that's the contractor's delay, there is no entitlement to extension of time. So these views have gone back and forth in cases that have come before the courts. For example, a relatively recent case is one of Saga Cruises versus Fincantieri Spa. In this particular case, Saga Cruises was the employer. They're the operator of a cruise ship operation, a tour ship operation, and they engaged Fincantieri Spa, an Italian shipbuilder, to renovate one of their cruise liners. What happened during the course of this contract is that there were substantial delays by Fincantieri, by the contractor, but also there were variations introduced by the employer during the course of the works, and especially towards the back end of the program. So the courts actually reviewed all of the previous authorities on concurrent delay, and they concluded that an important distinction needs to be drawn between an event which would have caused delay, but because there was already a pre-existing delay, has no delaying effect, so therefore does not give rise to extension of time. And that is distinct from an event which actually causes delay, but it does not give rise to an extension of time. So this is similar to, in line with view 2 that we looked at a little bit earlier, where the contractor's delay event overshadows the employer's delay event. So therefore, even though there may be a period of concurrency, actually does not give rise to extension of time. So in this particular instance, the court did find in favor of the employer and found that there was no concurrent delay. So the effects of this particular judgment, it narrows the definition of concurrent delay back towards the stricter approach that we looked at a little bit earlier. However, it seems to contradict the widely accepted Malmason approach. It has been criticized. It's come under criticism for its overly simplistic approach, and also that the application of causation is unclear, and also that the employer may benefit and backload variations. For example, if the contractor instructs variations at the back end of the contract, where a contractor is in delay, then the contractor may get the benefit of those variations without having to award any extension of time. The pendulum has swung back again in the other direction. This is a very, very recent case. It is a Canadian case. And in this case, this is by Schindler Elevator Corporation versus Walsh Construction Company. Schindler was appointed as a subcontractor to Walsh Construction in what I believe was a residential building. And there, the two competing views came into view with each other, into competition, so to speak. And Schindler's expert witness, he was of the traditional view. He took the view that true concurrency requires two co-critical and two controlling activities that are parallel in time and identical in duration. So pretty much the traditional or strict approach to concurrency. However, the court didn't actually agree with that view. They preferred Granier's view, who was the expert for the construction company, for Walsh Construction. And his view is more in line with the earlier view one, the less strict approach, which basically says that it's not necessary for the independent cause of delay to occur at exactly the same time for them to be considered concurrent. Indeed, it's rare that concurrent delays start and end at the same time. Concurrent delays are more commonly experienced as overlapping events. And I think as I think most people that actually assess concurrent delays in big complicated construction projects will agree that this is really what does happen a lot of the time. So Granier's approach, of course, is more realistic. It's likely to lead to a fair and just result because they felt that any other method would result unfairly in holding one party solely responsible for all of the delays on the project. So the effects of this particular judgment are that apart from us, the pendulum swinging back to a less strict approach, it's quite often unrealistic to actually expect a precise quantification of responsibility for delay. Overlapping events on construction projects often make such measure virtually impossible. And that the courts may prefer to split the responsibility for overall delay to prevent one party being held 100% responsible for the time and for the cost. Just as a note, the apportionment of delay is something that happens in Scottish jurisdictions, but it's not one that is preferred in English jurisdictions at this stage. Another development which is starting to come about is that there's an increasing popularity in incorporating provisions excluding the contractor's entitlement to extensions of time where there are concurrent delays. And this was tested in a relatively recent case, North Midlands Building versus Sidon Homes, where in that contract there was a pretty standard clause whereby the contractor is entitled to an extension of time if it's been delayed by a relevant event that the employer has got the risk for. However, that particular provision was modified basically to reflect that if that relevant event or that delay caused by the relevant event, if it was concurrent with another event which the contractor is responsible for, then there will be no extension of time. And the court actually upheld that provision in the contract and stated that provision is enforceable and it's not contrary to the prevention principle, presuming on the basis that the parties had agreed to that as a bargain between the parties at contract stage. So the effects of this particular principle or this judgment is that the employer will be able to recover delay damages for periods of concurrent delay, even though it may have caused some of the at least some of the delays to the completion period. And this is in conflict with the approach taken by the Society of Construction Law Protocol. So by way of conclusion, there still is no preferred approach to assessing extensions of time and delay damages where there is concurrent delay. It remains a very controversial and complicated topic. So the key to assessing concurrent delays is to be able to break down the overall delay into its component parts and look at those from a rational, logical point of view in order to be able to determine the actual delay caused by the parties and allocate associated risk accordingly. The analysis as to whether concurrency does exist or not, it must be based on a common sense approach. It should not be overly theoretical. It must make sense. And also, one needs to factor in for a margin of imprecision inherent in delay analysis. I think, as most practitioners will appreciate, delay analysis is not an exact science. It doesn't give you standard results to the day or to a couple of days. There is an element of imprecision in it. But however, where concurrency is established, the prevention principle should be respected. And the contractor should be awarded extensions of time where the employer's delay has concurrently delayed the project. But however, in terms of additional costs, the contractor should not be entitled to recover any additional costs unless it can actually prove that it would have incurred those costs in any event. So no costs in most cases where there is concurrent delay. I would like to say thank you for having been invited to this seminar, and that concludes my presentation. Thank you.
Hi everyone. I would like to first thank the organizers for inviting me to speak on a topic where on the face of it may seem a little bit out of place in the construction law conference, but I trust that many who are attending the conference today are legal practitioners who are practicing construction law. So the next 10-minute talk is dedicated to all the second chairs out there, or more affectionately, we are called the junior counsel on the team. But in Malaysia, we may not use the term second chair very often. We tend to lump everyone as junior counsel. It's not going to be a legal talk per se, but I'm going to share with you some of the things that I believe are important to take note of if you are the second chair or the junior counsel, especially in a construction dispute. Some of it may seem very obvious to you, but these are truly important and may also serve as a reminder to some of us. This is not meant to be exhaustive, of course, but hopefully it will help you to become a better second chair or junior counsel, and eventually you become a lead counsel yourself in the future. So I've got two main points. Point number one, it's very important as a second chair to know your lead counsel. You may think that knowing your file and case would be the number one thing that a second chair ought to do. Yes, as a lawyer, you are to know your file well, the issues, the facts, etc. You must be able to answer questions posed to you and able to assist the lead counsel in the hearing. But that is a given as a practitioner. To be a good second chair, you need to really know your lead counsel. Most of the time, the lead counsel is probably a direct boss in your law firm. So what is your boss's style of working? For example, is he the kind who would like to have many discussions before the case to discuss the matter together in meeting or your Zoom meetings nowadays? Is he the type of counsel where he tends to work on the file by himself and he will come over to you if he needs you to deal with certain research or look for specific things? Or is he the type that would not really be involved in the file until perhaps a month or 2 months before the actual hearing? Depending on the type of working style the lead counsel has, you or us, I include myself, as a second chair will need to prepare the case differently. For example, if the lead counsel tends to only look at the file a month or 2 weeks prior to the hearing, you would most likely have to prepare a more thorough briefing, a case file with summaries of the issues, list of witnesses, main facts in dispute, perhaps highlight the strengths and weaknesses of the case to him. This case file would have to be very thorough for if your counsel has this style of working. If he is the kind who tends to work by himself, you would then perhaps have to approach him, take the initiative to ask him how you may be of assistance, whether he needs you to prepare things like chronologies or core bundle of documents for his cross-examination purposes. At the hearing itself, if you know your counsel well enough, this will help the proceeding and give a sense of security to the lead counsel too. As a lead counsel, as you know, he or she may have many tasks to perform on the day, and at the same time, he or she will need to think, be quick on his or her feet to form questions or to respond to the tribunal's queries. As the second chair, our job is to, in a way, watch the lead counsel, listen to him or her and the way the proceeding is going to anticipate perhaps the necessary documents or information that your counsel would need. As you are expected to know the facts and documents well, you will be of greatest assistance to the lead counsel when you are able to locate the evidence as and when he needs it. For example, you could anticipate the cross-examination questions that you are able to suggest to your lead counsel or re-examination questions for his consideration. This is actually quite difficult in practice, but from my experience, the more you work with this particular counsel and observe his or her style of working, the better you would be at reading the room or reading his body language and also the direction of the questioning and submission. Of course, sometimes the second chair's position might seem more like a secretary or sometimes a cheerleader, a security guard, or even the case manager. However, I personally don't see that as a weakness or something that second chairs should feel, in a way, ashamed about. For example, if you know as a matter of fact that your lead counsel prefers to have coffee in the morning before a day of hearing, there's no reason as junior counsel you cannot take the initiative to ensure that coffee and tea is arranged. I mean, your lead counsel is comfortable, it will only benefit the case and your client. Perhaps you know your lead counsel is not very good with IT devices and definitely not comfortable with Zoom or Skype hearing, which is the norm nowadays. We as a junior counsel will have to ensure that everything is set up, working and ready for him or her to submit. Now that we are all working from home, or at least most of us are, we may not be able to set up a hearing room in the office for the counsel. You could suggest to have test runs of the Zoom hearing with the counsel, check the microphone, the speakers, offer to do the document sharing so that the counsel or the lead counsel do not need to deal with too many screens when he is submitting. Have a separate device set up for WhatsApp or Telegram conversations within the team. I think that's important because unlike in-person hearing, you cannot really pass the message across to your lead counsel easily. So that's number one, know your lead counsel because that will affect how you as a second chair can prepare the case. Number two, this is obvious, be familiar with the case and most importantly, documents. So in a construction dispute, one of the distinctive features of such disputes are the voluminous documentation filed in arbitration or construction litigation. If you are a construction dispute practitioner, you will already know what I mean. Most of the time, we do not ask each other how many bundles of documents are there, but we ask how many boxes are there to be delivered. As the junior counsel of the second chair, apart from knowing the facts well, able to understand and analyze issues, the lead counsel in the case will most likely rely on you, as in the most when it comes to retrieving documents, pointing out the relevant bundles, pages, or information on the document to him or her during the hearing itself. This is something that a junior counsel in a construction dispute has to master. The sheer number of documents and information may be scary at first, but this is something that is possible, perhaps with a few systems in place. So firstly, you need to be aware of what works for you and how certain systems may be of aid to you. Each lawyer's prep will differ from each other. For me, personally, I like to do chronologies, the gist of the event, and to list out the reference of the document according to the issues. When I go through documentation, I know that I'm able to digest and remember the documents better if I created a chronology of event and a separate column with the relevant documents referenced. But this may or may not work for you. Some of you may be better with visual documents or pictures, or perhaps I know some people who are very good at doing mind maps and diagrams. And if that works for you, that's great. So go with whatever works for you so that you are able to retrieve documents and information as and when the lead counsel needs it. So taking my example of the chronology, In a construction dispute, I tend to do a full chronology when it comes to issues of delay, EOT applications. I mean, these are just examples and the usual issues that crop up during a construction dispute. The EOT certificates, the CNC, the CPC. I will also tend to do a full chronology of defective works, the notices for defective works, rectification works, inspection, CMGD. I am then able to rely on this list during the actual hearing itself to find documents faster. I can also hopefully anticipate the questions I have in front of me, the whole sequence of events that happened during the project. So more often than not, I will also pass this list to my lead counsel so that it will be of help to him or her when forming certain questions or even answering questions from the judge of the tribunal. This exact same list will also not go to waste because you can use it for your written submissions at the end of the hearing. So apart from knowing your lead counsel, and number two is actually knowing your documents and where to find it, just a sub-issue is that you would know that during an arbitration hearing, the counsel would need our help, or we need to aid our counsel in terms of outstanding housekeeping issues. This is usually the very first thing that the tribunal will deal with on the day of hearing, and we as the junior counsel or second chair will be expected to prepare or at least pass the list to the lead counsel. One other thing that is important as a second chair to take note of is to brief your counsel on any outstanding housekeeping issues. This is usually the first thing that the tribunal will deal with on the day of hearing, and I think it would be of great help if we can list it out to our counsel so that he or she is comfortable to start off the day, and he can then move on to the cross-examination or even submissions later. So even if it's something that you believe the counsel already has knowledge of, personally, it doesn't hurt to still prepare the list of housekeeping issues and to pass it to your lead counsel prior to the hearing. So most lead counsel in a construction dispute, especially in a larger dispute, do not run the file on their own. They will need the support of a team, and lead counsels know the importance of having a good second chair or junior counsel on the team. They may not express their gratitude very much, and sometimes the preparation that you do may go unnoticed, but please remember that your role as the junior counsel or the second chair, especially in a construction dispute, is vital. You are not just a note taker or the stenographer or the person who prepares coffee and tea or passes documents to your lead counsel. If we, and I include myself in this, as the second chair do an excellent job at assisting the counsel, this will take away immensely the pressure on the counsel, and he or she can focus during the hearing without the need to worry about other things because he knows that you've got it covered. So I hope, in this 10 minutes, the two main points above will be of help to you or serve as a reminder to you as a junior counsel, the importance of your role in the team and how you can be a better second chair. But if you are a lead counsel listening to this short presentation today, perhaps it is time to show your appreciation to your junior counsel on the team. It's good to always have the support of a great team, and you can then have smooth proceedings. But that's it from me. So enjoy the rest of the conference. Thank you, everyone.
That was truly enlightening, but we are not at the end of the show yet. We still have two more speakers who are Dr. Colin Ong, a master of the bench of the Inner Temple Queen's Counsel and chartered arbitrator, as well as a senior partner of Dr. Colin Ong Legal Services. And introducing a brand new speaker making his debut tonight, Dr. Zul Zakiuddin, who is the head of the School of Housing, Building and Planning in University Science Malaysia.
Thank you very much for the introduction, Huyen. Remoteness of damage is often a problematic issue in damages claims for breach of contract. Liquidated damages clauses or LAD clauses spans the non-breaching party of having to deal with remoteness issues. The essence of an LAD clause in a construction contract is that the party in breach of its obligations is contractually obliged to pay a particular sum by way of compensation for that breach. And the sum specified in an LAD clause is payable once breach occurs. There is no need to wait around for the loss to crystallize. The aggrieved party is spared the time and expense of a typical common law action for damages for breach of contract. And the LAD clause also spares the obligation to mitigate, as would be the case in an ordinary claim. English courts tend to uphold LAD clauses in a construction context, especially where the parties are of equal bargaining strength and they are free to apportion the risks between themselves. The previous test under English law was that a penalty clause was unenforceable. Over a century ago, in Dunlop Pneumatic Tyre and New Garage and Motor Company Limited in 1914, the House of Lords held that a penalty clause is essentially a sum of money so unconscionable in comparison with the greatest loss that could possibly result from that breach of contract. Under the Dunlop test, the enforceability of an LAD clause depended on whether it reflected a genuine pre-estimate of the likely loss that the innocent party will suffer upon the defaulting party's breach. The Dunlop test is predicated on the principle that the sole purpose of an LAD clause is to compensate an innocent party for losses. An LAD clause that seeks to compensate for sums greater than the sum that ought to have been paid is considered to be penal in nature and is therefore unenforceable. The UK Supreme Court reformulated a test for penalties in 2015. In Cavendish Square Holdings and Talal El-Maqdisi, the Cavendish test was developed to focus on the legitimate interests of the parties. And the Supreme Court distinguished between primary obligations and secondary obligations. Primary obligations are those legal obligations that are imposed upon each party to fulfill what they had promised to carry out. And the breach of the primary obligation would lead to the secondary obligation to pay monetary compensation for damages suffered by the aggrieved party. This distinction is highly significant as the penalty doctrine does not apply to primary obligations. Under the Cavendish test, there are three separate components that one needs to consider. First, does the LAD clause provide a concern, a primary obligation, or a secondary obligation? Second, does the aggrieved party seeking to enforce the LAD clause have a legitimate interest? And third, is the stipulated sum under the clause out of all proportion to such legitimate interest? The determination depends on the circumstances of each case. In a contract between properly advised parties of similar bargaining strength, the strong initial presumption is that parties themselves are the best judges to decide what is legitimate in the clause dealing with the consequence of a breach. Let me now share my single slide as I'm about to refer to a seminal decision of the Supreme Court in Triple Point Technology and PTT Public Company. This judgment was handed down exactly 1 week ago on the 16th of July. Let me just share. No. Perhaps I could ask the technicians to assist me to put my slide up. Well, while that's coming up, the primary question that was facing the Supreme Court was whether damages, it's come up, brilliant, was whether that liquidated damages should be payable in circumstances where the work was completed before termination. The Court of Appeal in Triple Point had departed from the general approach to LAD clauses, and it radically concluded that an LAD clause would not apply even where a contractor was responsible for delay and had failed to complete the work on time. The Supreme Court held that the Court of Appeal's decision was inconsistent with commercial reality and the accepted function of liquidated damages. Liquidated damages clauses are meant to provide a predictable remedy. It ensures that an employer does not have to undertake difficult and time-consuming tasks of quantifying its actual losses. So the Supreme Court clarified that the accrual of liquidated damages comes to an end when the contract is terminated. At the time of termination, where liquidated damages for delay have already accrued, the court held there was no reason in law why termination should deny the employer its right to recover liquidated damages. The Supreme Court also observed that liquidated damages clauses provide certainty to parties by allowing damages set out at specific rates for each period of delay in the completion of work by the contractor. Key takeaway point from Triple Point is that delay LAD provisions apply up to the date of termination of the contract, even where the works are incomplete. And obviously, after termination, the correct remedy would be a claim for general damages. I shall now deal with the Singapore law position on its treatment of penalties and LAD clauses in construction. On the 15th of December 2020, the Singapore Court of Appeal in Denka Aventek and Soraya clarified that the Singapore test to determine whether an LAD clause is a penalty is that in Dunlop. The Court of Appeal declined to follow the legitimate interest test in Cavendish for three reasons. First, the test in Dunlop as to whether the LAD clause provided for a general pre-estimate of likely loss is consistent with the Singapore law position that damages ought to be compensatory rather than punitive. And the Court of Appeal had in its earlier decision in PH Hydraulics and Engineering and Air Trust Hong Kong held that as a general rule, punitive damages cannot be awarded for breach of contract. And second reason why the Singapore Court of Appeal rejected Cavendish was because it was inconsistent with this rule, because it would allow for enforcement of any LAD clauses that operate upon the breach. The LAD clauses may not be a genuine pre-estimate of likely loss, but if they are still held to be commercially justifiable, they would be upheld according to the Cavendish test. Finally, the Court of Appeal held that the manner in which the concept of legitimate interest was framed in Cavendish, it had a protean nature because it would allow it to be used very flexibly, and this would create too much uncertainty. It's interesting to note that while the Singapore Court of Appeal rejected the legitimate interest test in Cavendish, it held that factors including commercial interest, bargaining power of the parties, and the parties' objectives for entering the contract are relevant and should be looked at when one is deciding whether an LAD clause is penal in nature. I should also stress the importance of Denka and Soraya. It was heard and decided by 5 judges at the Singapore Court of Appeal instead of the usual 3 judges. I'll now sum up the Malaysian position on the treatment of penalties and liquidated damages. We've heard earlier speakers deal with it, so my task is made easier, but I may have a different conclusion. So the employer's entitlement to liquidated damages in India, Malaysia, Brunei, this is encapsulated in the wording of Section 75 of the Contracts Act. And the Federal Court's decision in Cubic Electronics pertaining to the interpretation of Section 75 of the Contracts Act had obviously changed the law on recoverability of liquidated damages. The federal court in Cubic reinterpreted Section 75 and took a different approach to its earlier decision in Selvakumar and Tagaraja. Selvakumar had earlier decided that the contract had, that where a contract had been breached, an innocent party could not recover simpliciter the sum that had been fixed in a LAD clause, but it had to instead prove the actual damages that were suffered. The Cubic Electronics held that Section 75 of the Contracts Act allows reasonable compensation regardless of whether actual loss or damage is proven. While proof of actual loss is not mandatory, the court did state that evidence of such damages is useful when you come to resist a challenge by the employer, because there are two tests to Cubic. The first step is for the aggrieved party seeking to enforce the LAD clause to show a breach of contract. It then has to identify the LAD clause and set up the sum that has to be paid upon breach. The second step of the test then shifts the burden of proof onto the defaulting party. So the defaulting party would have to show that the LAD clause, including the sum claimed, is unreasonable. And the federal court held that a stipulated sum is unreasonable if it is very high or unconscionable in comparison with the highest possible loss which could have flowed from the breach. And the crux of the decision in Cubic is that the burden of proof has shifted for an LAD clause. It's shifted to the defaulting party. And generally in construction contracts, it means that it's the contractor and not the employer who would have to prove that the LAD clause and the stipulated sums are unreasonable. So following Cubic, LAD clauses negotiated at arm's length between properly advised parties are likely to be upheld. Now, I should conclude, I think, by stating that it seems that the federal court did not fully adopt wholesale the Cavendish test for primary obligations and secondary obligations, but it did note that there was nothing objectionable in holding concepts of legitimate interest and proportionality as was set out in Cavendish. So it's quite similar to the Singapore Court of Appeal, where they also did not accept Cavendish, but accepted certain factors. With that, I think my time is up. Thank you for your attention.
Hi there, good day. I am Dr. Zul Zakiyuddin Ahmad Rashid. First of all, I would like to say thank you to the organizer for allowing me to contribute and share some insights on one of the topic relating to the construction industry. So the topic I will be talking will be construction industry toolkit, understanding the rights and obligations for payment. Ladies and gentlemen, behind in every toolkit of whatever industry, there are essentials allowing the stakeholders to perform and execute their job accordingly. So one of the essentials in the toolkit of every stakeholders of the construction industry, I would say, relates to payment. So saying that, let's give it a thought. What are the elements that confers you the right to claim and confers you the right for payment? So basically, by way of the law, you have a right for claim and for payment, which derive from a contract, which is a contractual right, as well as outside the contract, which is a non-contractual right. So in the nutshell, you can claim out of the contract itself. You can also claim for payment outside the scope of the contract. How it is possible? I'll give you a scenario where a contractor can claim for work done, for work carried out outside of the term of the contract, and the employer is obligated to pay the contractor for the works carried out. So the example might be in the case where a contractor was instructed to carry out a VO work, a variation order works, without a proper VO being issued, a proper VO instruction being issued by the consultants, by the SO, whatever case it might be. So in that scenario, without a proper documentation, can the contractor, upon completing the work, claim for the work done, for the payment for the work done? So we need to understand the scenario, the requirements provided by the law in allowing such circumstances to be claimed and impose the right to pay to the contractors for the work done by referring to one of the act in Malaysia, which is the Contracts Act 1950. To be exact, Section 71 of the Contract Act 1950. So what is all about with Section 71? Section 71 of the Contracts Act outlined the elements when a contractor can claim for work carried out outside the contract when, number one, it is a lawful job he completed. He carried out a lawful work. Secondly, it is done for another person, not for his own interest, not for his own benefit. I'm saying that it is carried out for the benefit of others, and it is not carried out gratuitously. It is carried out as a commercial practice. So if the contractor fulfill all these elements as provided by Section 71, even though when he carried out outside of the contract, he is given the right to claim for payment. Basically, this come out under the principle of quantum merit. Okay, another example when the right to claim, and it does happen frequently in the industry, is when, for example, a client terminated the main contractor, and the main contractor have a subcontractor to carry out certain work for the project. So this subcontractor will have the right to claim for the works carried out by the subcontractor, even when the main contractor was terminated. There is no direct contract between the subcontractor and the client. The subcontractor only have a contract with the main contractor. They don't have any right, any contract with the client. However, by virtue of the quantum merit principle, the subcontractor, upon completion of the work for the client, which is carried out and enjoyed the benefits of such work by the client, whatever work carried out by the subcontractor is entitled to be claimed and obligated to be paid by the employer, by the client. So you have to understand that. Okay, secondly, the right to claim and the right for payment might also arises out of the contract itself. We call it as the contractual rights for payment. So this is clear. So how it arises? It might arises from a progress claim as well as interim certificate, and also out of the final certificate to be issued by the certifier, consultants, or perhaps the SO. So I will now talk about interim certificate. Well, this is where most of the contractors will be dealing with. Not to say that final account is not important, but given the duration of time, so I might just focus my attention, at least for this time around, on the legal position relating to interim certificate. Ladies and gentlemen, let's, if we go through all the contracts we have in Malaysia, the standard form of contract in Malaysia, when we talk about certificate, interim certificate, the common facts, the common elements that we have throughout all this standard form of contract will be a progress claim should be submitted according to the timeline. For example, towards the end of every month, that give right for the contractor to claim for payment. Progress payment can also come out from progress percentage of the work carried out. So these are the second scenario where contractor might be allowed to claim out of the contract, depending on the terms agreed by the parties. And another thing that you need to understand as well, if you go through all the standard form of contract we have in Malaysia, that this claim for payment must be supported by the relevant documentations. So this documentation required are basically generally illustrated, required, imposed or stated in the contract itself. Okay, if not sufficiently provided, then the certifier will carry on, perhaps depending on whatever documents and information that he have before him to proceed with the certification, and later on proceed with the interim certificate. And upon submission of the complete claim for payment with all the relevant documents submitted, it is the duty of the certifier to give it a look, consider it, and subsequently certify it. So it is not uncommon also in industry where the contractors will receive an under-certified work by the certifier, or to a certain extent, there may also be an over-certified work certified, evaluated by the certifier. It is not to be worried because the process of the industry, such under-certified or over-certified amount will be readjusted in the subsequent certificate. Yeah, so not to worry so much about that. It is not a final determination of the work done. Yeah. One thing I need to raise the attention of the audience is the timeline when it involves claim for payment, the certification by the certifier, by the consultants or the SO, whatever case it might be, and the payment to be made by the client or the employer. So when the contractor submit the claim, does he have the right for immediate payment, or is it obligated for the employer to pay him there and then? The answer is no. General saying that if you refer to the general construction contract we have, on the standard of contract we have throughout Malaysia, when the contractor made a claim, there will be a time for the certifier to analyze it and later issue a certificate. And upon the issuance of the certificate, the client need to make a payment to the contractor. This is what the law says. Upon the certification, client need to pay the amount to the contractor. One point need to be understood is that it is not there and then the client need to pay the amount to the contractor. So in general term, if you look at the general standard form of contract we have in Malaysia, will allow certain duration to be given to the employer to make such payment. Technically, if you refer to some of the contract, it is term as period of honoring the certificate. So for the contractor to have the right to challenge, to sue, or to bring the matter, for example, to arbitration or adjudication, you need to understand when this right arises. So the contractor can initiate with that action upon the lapse of the period of honoring the certificate. So we does not want a premature claim or premature action initiated by the contractor without the understanding of the timeline given to respective parties. Okay, there are cases where contractor says that they are entitled for payment without going through the contract, and subsequently we notice that the time is actually within the contract as provided by the contract, and the client has all the right as per contract not to pay the contractor yet. He's not, in other words, the client is not obligated to pay yet by virtue of the contract terms. So, ladies and gentlemen, saying that it is important for the parties to understand the requirements of the contract to fulfill whatever the obligations stated by the contract. And when we talk about certificate, it is actually a condition precedent before payment is made. What if certifier, the SO, the consultant fail to carry out his duty? Does that leave the contractor with no rights to claim? There is a right. So if I may have the opportunity to talk about SIPA, is one of the platform where the contractor can initiate an action for claim even when the consultant failed to issue a certificate. In fact, SIPA empowers the adjudicator to issue a certificate and eventually allowing payment to be made to the contractor for the work done. Ladies and gentlemen, before I end up my session, I would like to perhaps look at the issue from the perspective of the industry. It is important for everyone to follow the process and the procedure stated by the contract for a successful claim. Then hopefully with that we can avoid various issues relating to progress claim and payment due to the technicalities or errors relating to technicalities which lead to undesired consequences, not to just to the contractor, but to other parties as well. With that, I would like to say thank you. And again, thanks to the organizer, and hope to see you guys very soon in other session. Thank you very much.
The range of topics was varied, but all very relevant in the construction industry. I hope you also enjoyed the fresh topic by Dr. Zul Zakiuddin. Tomorrow, we will be exploring the common challenges in variation order claims and how to overcome them.
The topic of our session today is common challenges in variation order claims and how to overcome them.
The contractors program is important for two reasons. Number one, it must show how he plans to do the work.
But how on earth do you negotiate with unreasonable people?
I've been here for 24 years in Malaysia. I've found that Asian people generally mediate anyway.
If you walk into a negotiation and if you just walk in and shake everybody's hands and you get everyone in the room to shake each other's hands.
I don't agree with that view. I think